Hello everyone. Dear students, welcome to session 8. This is my 8th video for public law with you. This is also part 3 of prerogative powers. This is my 3rd question on prerogative powers, and the question that I'm doing will be on page 9 of your prerogative powers notes. So the handout entitled prerogative powers, which I uploaded a few days ago. If you have already printed it out or you are viewing it on another device, it would be page 9, right? So page 9 is question 2016, zone A, question 4. Explain and evaluate the need for the reform of prerogative powers. Explain and evaluate the need for reform of prerogative powers. Now, the first thing that I want to say to you is, it doesn't mean that the whole question you only talk about reform. Because it says explain and evaluate the need for reform. So why would we want to talk about the need for reform? The need for reform is necessary if control is inadequate, isn't it? So you see how even this question, you still have to talk about controls. You have to talk about the fact that the controls may not be adequate. And that's why we need to reform. So it does not mean the whole question is on reform. Okay? So if you look there under the suggested approach on page 9, you would still start off with the sources of the Crown's executive power. You would still look at the role, the justification for prerogative powers. You would look at the scope of prerogative powers. You would still refer to the political and legal controls. Now, I'm not going to go through those political and legal controls again because I've already done that in videos 1 and 2, part 1 and 2 of prerogative powers, right? So those videos are longer because I've already gone through that in videos 1 and 2. Yeah, so I won't bore you with that. And then the relationship between prerogative and statute and human rights, we've been through that as well. And then the need for reform, the options for reform, and conclusion. So in this video, I'm going to spend more time looking at reform of prerogative powers. All right? So halfway down on page 9, I've actually put a caveat there. I've said that for discussion of the other issues, please refer to the suggested approach in the 2019 question at the beginning of this handout. All right, everyone. I hope that everybody is clear. Yeah. So in looking at reform of prerogative powers, I've broken my answer up into several headings. So number 1, I've said that one possibility is for us to take all prerogative powers, put them all on a statutory footing. Okay. Now, and then we can discuss what are the arguments for this and what are the arguments against this. So this one is about us codifying all prerogatives into one super statutory code, as it were, or even as part of the process of the written constitution. So we'll come back to that. So one possibility is for all the specific prerogative powers to be put on a statutory footing, all in one document. If you turn to page 10, another possibility, number two on reform. Another possibility, and this is less radical, is a lot more manageable. It's the one that I'm going to put forward for the future, is to take a specific prerogative power and codify that. So for example, the Constitutional Reform and Governance Act, that codified 2 prerogative powers: ratification of treaties, and secondly, so A, ratification of treaties, secondly, B, regulation of the civil service. So that's a good one to talk about. And then if you turn to page 11, another example of a prerogative power that was taken and codified, and it's been working well since then, is dissolution of Parliament. And this would be under the Fixed Term Parliament Act of 2011. That's another example of a particular prerogative being codified, and is a good job. Okay, so that's two ways of codifying. The first way, take it all, put it in one super code. The second way is take one prerogative, take two prerogatives, put it into a statute. The third to look at on page 11 is, what about other prerogatives? What about some problem areas? Could we take them and try to reform them in some way? For example, the prerogative of deployment of troops abroad, the prerogative of declaration of war. Now, these are things which are very, very provocative and controversial types of prerogatives. So, should we reform them? Because there's a lot of power given to the Prime Minister here. Should we, reduce these powers? Is it possible? And then if you turn to page, so I've got a discussion there about deployment of armed forces. Then I come to page 13. And the fourth area that I want to talk about for reform is, what about an act of state? What is an act of state? What did the Muhammad and Rahmatullah case, what do these cases say about an act of state? Can we reform it? And then I will come to a conclusion on what's the need for reform and which method I favor and why. All right. So that gives you a gauge of what are the things I will be looking at in answering this question. So let's go back now to page 9. And if you've forgotten what the question is, let's just remind ourselves at the top of page 9, the question is, explain and evaluate the need for the reform of prerogative powers. Okay, so we've already done the first part, which we're talking about what are prerogative powers, how are they controlled, the need for control, both political and judicial control. And we've also said that, well, there's a need to reform because, sometimes prerogative powers are used and we don't seem to know what's the exact scope of that power. And this happened in Miller number 1, the Prime Minister's prerogative power to invoke foreign relations and to invoke Article 50 of the EU Treaty. And 8 judges in the Supreme Court said that I beg your pardon, Theresa May at that time could not invoke that power, but 3 in a dissenting judgment given by Lord Reed said that she could. So maybe we should codify this. So what are some of the arguments for reform? Let's take number 1. So let's take this one. It's an ambitious proposal, but one possibility is for all the specific prerogative powers to be put on a statutory footing. Now, what would be some of the arguments for such a drastic move? Number 1, clarity. Number 2, certainty. In other words, to be sure of the scope and extent of that prerogative power. It would be laid out in the statute. The circumstances for its use would be laid out. At least that would be a starting point for the courts to look at, to see whether something is ultra vires, to see whether something is an abuse of discretion. So the statute could act as an aid to interpretation of the scope and powers of the power, of the scope and extent of that power itself. It's also important from the angle of democracy, accountability and transparency, so that people who are in power must not feel that they can use their powers without having to explain for them. Right? It's also important because, well, we can say that if we codify, it will result in enforceability in court. It will result violation of the power, all right, a violation of the proper use of that power, rather, or if there's an abuse of power, there can be sanctions in a court of law. Damages may be given where the court can scrutinize the use of this power, and if parties have suffered loss as a result, they may obtain remedies. So these are all some of the arguments for codification. Let's now contrast that with some of the arguments against codification at the bottom of page 9. Now, the first and perhaps most important one would be loss of flexibility. So at the moment, you've got that flexibility, and ministers need that flexibility. If you were in the government, You wouldn't want it to be, you probably will not want your powers to be codified. There will be a loss of pragmatism. What does pragmatism mean? Practicality, right? Loss of expediency in government. Sometimes you need to act fast. For example, during this COVID-19 pandemic, the government needs to act fast. It has to come out with prerogative powers as well as to emergency powers as to what it can do to ensure peace. Now, there's no time to think, because sometimes you need to come out with a policy or a decision extremely fast in order to maintain the order, stability, peace, or indeed at the moment health of a nation. So you need to have these powers. Codification would also lead to loss of secrecy in the operations of government. And later we will talk about deployment of armed forces abroad. If you codify this, there will be national security concerns. So these are some of the arguments against codification, right? So it depends what you think. So you might feel that you're more, despite the arguments against, you still prefer the arguments for codification, because at least it may lead to the powers being more clearly defined, being able to be subject to more parliamentary and judicial scrutiny. So that's an option. The second option, and in my opinion, this option is far more realistic, simply because it's not over ambitious and it deals with one area at a time. So this one would be another, number 2, and this is on your page 10, another possibility, which is a less radical alternative to codification, is to convert certain prerogative powers to statutory powers. So for example, ratification of treaties under the Constitutional Reform and Governance Act of 2010. So the CRGA of 2010 is a code. It's a statute. It sets out what is the procedure to ratify an international treaty. So it replaces the old convention, what we call the Ponsonby Rule. It's called the Ponsonby Rule after General Ponsonby many decades ago, right? In 1924, he was the Foreign Office Minister, Arthur Ponsonby. So he came out with the convention. But as you know, conventions sometimes are not clear. It's better to codify. So the CRGA now says, part 2 of it says that under section 20, there are 3 preconditions that the government must meet before ratifying a treaty. First, it must lay a copy of the treaty for Parliament to see. Second, it must be published in a way that the Minister of the Crown considers to be appropriate. Third, the 21-day rule. The government must wait for 21 sitting days after the treaty has been laid out without either house voting against ratifications. Now, what happens if a house does vote against? The answer is it depends which house. If it's the House of Commons which has voted against ratification, then the government is blocked from ratifying it. Okay? The government must bring it back to Parliament again, must look at it again. If the House of Lords is the one that is blocking it, then it's not such a serious thing, because that vote is not binding on the government. Why is that? Because the primacy of the House of Commons must be respected. It is the democratic body. Note also section 22, which section 22 gives an exception. It says that exceptionally a treaty may be ratified without the government satisfying those above set conditions, and the government would have to justify why it was doing that. It can still proceed, all right? And then what else does the CRGA also do? If you turn to page 11, the other area that the CRGA codifies, the other prerogative power that it codifies, is the regulation of the terms and conditions of the civil service. Now, if you recall the case of GCHQ in 1985, the Prime Minister, Margaret Thatcher at the time, she had the prerogative power in an order in council of 1982 to regulate the terms and conditions of the civil service as she saw fit. You see how broadly that's phrased, the prerogative power? As the Prime Minister sees fit. That means she can do whatever she wants, isn't it? That's how she took away the right of the members of GCHQ, the employees, to belong to what? To belong to the trade union. Because the wording of the prerogative power, the order in council, was so broad. That's how she got away with it. So, was it necessary to codify this? Of course. The Prime Minister should never be allowed to be given too many powers over the civil service. Of course, you might be the head of the executive, but it's better for it to be codified, because then the courts can act as an independent scrutiny mechanism in case there's abuse. Yeah. So the CRGA is a good reform because it lays down what is the procedure to ratify treaties. It also codifies the prerogative power of regulation of terms and conditions of the civil service. So in a sense, both of these are important because they reduce the powers of the Prime Minister. And in my opinion, that's always a good thing. I don't like Prime Ministers having too much power. I don't think that it's a good thing. They can have lots of power, but it must be available for it to be checked. So sometimes when we codify it, it becomes smaller, more self-contained, which is a good thing, right? Okay, that's that. Now, what else can we talk about? What are some of the other examples? If you look halfway down page 11, can you think of any other prerogative power that's been codified in 2011? Which act was that? Can you remember? Well, not to worry if you can't remember. If you see there, it's called the Fixed Term Parliament Act of 2011. Now, the Fixed Term Parliament Act of 2011 was important. It was passed during the coalition government of Cameron-Clegg from 2010 to 2015. So why did they pass this? Because they were scared they wouldn't last for 5 years, because it was a coalition government. They were scared that they may crumble, but they didn't. They lasted. So this act said that if any Prime Minister wants to call for an election and it's not been 5 years, the 5-year term is not up, they must seek consensus, get 2/3 majority in Parliament, so that they're justified in calling for another general election. This is a good thing, because a general election is such an expensive thing, using so much public funds and resources from of the country. The taxpayer pays for it. So you can't simply go and call for a general election unless, there's justification for it. So in the last 5 years in the UK, there have been 3 general elections from 2015 to now. 3. There should have just been 1, right? There have been 3. Okay, so each time when Theresa May wanted to call for a general election, when Boris Johnson wanted to call for a general election just recently, a couple of months ago, they had to get that 2/3 consent from Parliament. So that acted as a checks and balance on their powers. Very important. So that's a good reform that has happened. And then bottom of page 11, what about some other prerogative powers that you could also talk about? So for example, what about the prerogative of deployment of troops abroad and declaration of war? Now, if you look at page 11 at the bottom, the decision to go to war, I've stated there, is arguably one of the most important decisions any government will make. So whether you're sending your troops to Iraq or Afghanistan or wherever, this is a huge decision with tremendous implications and costs for the nation. So therefore, some of the issues that arise here is the Prime Minister should be able to get enough of a consensus and backing of Parliament before these decisions are taken. Should we codify this? Now, bottom of page 11, what are some of the advantages and disadvantages in relying on statute as opposed to convention? Is it something, if you turn to page 12, is it something which would be amenable to put into a codified form? If you put it into a codified form, would it reduce the morale of the armed forces? Now, imagine if you were working in the army, if you were a member of the armed forces, and somebody later questioned what you did, and you became subject to a great amount of scrutiny. Some people argue that, we must show gratitude for our armed forces. They must be given certain types of immunities because they are there fighting for our country. all right? A little bit like, imagine the frontliners in the health services now with the COVID-19. So we must feel that they should be given some immunity, right? Some protection. You can't simply go and attack them because they're laying their lives for us. So is it a good idea to put it into a codified form, right? What are the arguments for? You've got clarity, you've got certainty, but how would you actually put it? How would you create that clarity and certainty? It's not that easy. It would also raise issues concerning national security. The government may not be able to expediently. So instead, what's happened, and you can see this on page 12, is there's been an evolving convention of how this comes back to Parliament and how Parliament discusses it and ratifies that behavior to send troops, whether to Syria or Afghanistan. And that's become an evolving convention. So perhaps in this area, perhaps you may decide that that's enough for the moment, and codification of deployment of armed forces may not be a good idea because it's ill-suited to be codified. And then on page 13, what about acts of state? In the Muhammad against Ministry of Defense, the Rahmatullah case, the Supreme Court unanimously told us in a recent decision in 2017 that acts of an inherently governmental nature in the conduct of foreign military operations by the Crown were Crown acts of state for which the government cannot be liable in tort. Now, so a Crown act of state is an aspect of the royal prerogative relating to what? Government policy in international affairs. So it's a high policy decision. Here, what did the court say? Yes, whether the issue was justiciable or not, you must be very careful, because if it is something which is classified as an act of state concerning foreign affairs, the court is not going to review it. They are not going to say that it's justiciable because it will affect national security. But what exactly is an act of state? Is the meaning of act of state clear? The answer is no. But would codification help? I don't think it would, because each case would depend on its circumstances. And indeed, in the Muhammad and Ministry of Defense, the Supreme Court is telling us that each case be turned on its own facts. So some prerogatives, like an act of state, may have to be left how it is, though it is somewhat unclear. There's a grey area here, but perhaps that's necessary, okay, for government to be able to do what it does, especially in relation to relations with foreign countries. Okay. Now, conclusion. So at the end of the day, is there a need to reform prerogative powers? Well, political control we saw is inadequate. Judicial control is getting better. After the Miller decisions, we see a new kind of judicial activism. But should we reform? Why not? I would conclude by saying that there is definitely, to me, two prerogatives that we can go and put on a codified form, which are what? Both relating to the Prime Minister's prerogative powers. So remember, in Miller number 1, it was the prerogative power to use her foreign relations, and she used it to invoke Article 50. Remember, 8 of them in the Supreme Court said that she couldn't do that. 3 of them, in a dissenting judgment by Lord Reed, said that she could. So we're not clear, right? What's the scope of that? Why don't we codify that? Put that into a codified form, put it into a statute. In Miller number 2, there's so much hoo-ha about prorogation of Parliament, the Prime Minister's power. Perhaps we should codify that. It might be difficult to codify that because it might be difficult to stipulate what are the circumstances for prorogation. But maybe we can codify that by saying that the Prime Minister still has this power to prorogue Parliament, but in the event that he decides to prorogue Parliament and exercise that power, he needs to give reasons for this in a clear form, perhaps in a written form to the floor of the House of Commons. So that could act as a checks and balance on the use of Prime Minister's prerogative powers. So you can finish your answer by saying that these two prerogative powers of the Prime Minister, foreign relations and prorogation of Parliament, could perhaps be put on a statutory form. Codifying all of them may not be a good idea because it would be too radical. And as we said, some types of prerogative powers like deployment of troops abroad and acts of state may be difficult for national security reasons to actually put them onto an act of parliament. And it may not be desirable as well. It may be unnecessary and undesirable and perhaps even impossible to codify deployment of troops abroad and act of state. But these other prerogative powers of the Prime Minister, which I mentioned, we could certainly codify that. We could even say that some of the archaic prerogatives of the Queen, for example, owning, swans, stuff like that, we should just abolish those. We don't need those anymore. All right. So that brings us to the end of the topic of prerogative powers. Do end, if you look at page 13, I've put, conclude on this, the need for reform. What's your preferred option for reform and why? So just like how I said what my preferred option was, you might want to state what yours is to give your answer that personal touch, and to tell the examiner that you fully understood what are the ramifications of reform. Right? I hope that this answer has helped you to understand this topic better. I look forward to see you in my next video, which will be video number 9, and that will be on ministerial responsibility. All right. Thank you for listening. Thank you for watching. I feel like I'm reading the news or something, but that's the best that I can do for now. I'm sorry that it's monotonous and you have to keep seeing my face. It's the best I can do in the circumstances. Yeah. Thank you once again. Bye-bye for now. Good night.